Okay, let's dive in. This headline just exploded. Justin Baldoni damns Blake Lively for sham lawsuit. Actress's lawyers respond. Wow.
Yeah, damns, sham lawsuit. I mean, that's not pulling any punches, is it?
Not at all. And look, we're not just going to skim this. This is the deep dive. We've got the article. We've got context. We're going to try and piece together what's actually happening here.
Exactly. Forget just the back and forth. We need to look at the timeline, the claims, the counterclaim.
This deadline piece is about something else, this unrevealed lawsuit.
Which adds a whole new layer. Our mission here is basically to dissect this article, pull in what else we know, and try to understand the strategy, the timing, everything.
So back to the headline. Justin Baldoni damns Blake Lively for sham lawsuit. Actress's lawyers respond. Baldoni's side coming out swinging, calling it a sham. That's a heavy accusation. Bad faith, basically.
It really is. And then Lively's lawyers, very concise, nothing to hide. It's such a contrast, you know?
Totally. Aggression versus this projected confidence sets the stage, doesn't it?
Definitely. Okay, paragraph 1. This previously unrevealed subpoena-seeking lawsuit filed 5 months before the main complaint we all heard about.
So like a preliminary move. It wasn't just a reaction, it was proactive. Okay, paragraph 3. This talks about a treasure trove. Big words.
Yeah, incriminating and unpalatable texts and other correspondence from Baldoni's PR team Melissa Nathan Jennifer Abel, apparently revealed in a September 27th filing.
But here's the twist, right? Lively's name isn't on this suit. Ryan Reynolds isn't either.
Nope. The plaintiff is this company, Vanzan, Delaware corporation, set up way back in 2010. Lively listed as CEO.
Vanzan. Sounds very corporate shield, doesn't it?
It has all the signs, yeah. Using a company like that, it gives distance, lets you gather intel without putting Lively's name front and center right away.
Smart move, maybe? Avoid scrutiny while you figure things out.
Could be. A tactical play to control the narrative, maybe avoid tipping off the other side too early, and that treasure trove line suggests whatever they got, it felt significant.
So Vanzan, this Delaware company, is suing 10 Does. John Doe's, Jane Doe's, basically.
Right. Paragraph 4 lays out the claims in that Vanzan complaint. Failing to act in the plaintiff's best interests.
Self-benefit at the plaintiff's expense. Lack of communication.
And disclosing confidential info. Pretty standard breach of duty stuff, really.
But the lawyers for Vanzan, Manet, Phelps and Phillips.
The same firm representing Lively, Reynolds, and their PR lead Leslie Sloan in the other big public suits against Baldoni.
Okay, so it's all connected. This wasn't some random side thing. It's part of a larger strategy.
Absolutely, it reinforces that. The Vanzan suit, even though separate on paper, seems totally integrated with their main legal push. The claim suggests they thought these unnamed people were actively undermining Lively.
Which brings us to the subpoena. Paragraph 5. This gets murky.
Yeah, so Jones and Team Blake, as the article calls them, they insist Jones handed over Abel's device's phone, everything after getting a subpoena.
But Baldoni's lawyer, Brian Friedman, apparently doubted that, publicly questioned if the subpoena even existed.
Right. Which suggests Friedman's side might have thought the info was obtained differently, maybe less formally, or maybe improperly.
So the existence and legitimacy of this subpoena becomes a key point. Was it legit? Where did it come from?
Exactly, because Lively's team is saying, no, it was compelled by a proper subpoena.
But then, paragraph 6, plot twist. Friedman's not doubting that subpoena anymore.
Whoa, okay.
Yeah, nor, quote, what it all means. That's a big shift from doubting its existence.
Huge shift. Something must have happened behind the scenes. Maybe they confirmed it existed, or they realized the implications.
Whatever it was, it seemed to have lit a fire under him, leading to paragraph 7. This is where he calls the Vanzan suit a sham.
Right. His quote is strong. Mrs. Lively's and Mr. Reynolds' company, Vanzan, had nothing to do with this case, and they knew it.
His argument is basically that Vanzan was just a front, right? A way to get subpoena power without oversight or scrutiny.
Exactly. He's saying it denied his clients the chance to fight the subpoena properly, challenge its scope, its basis. It's an abuse of process argument.
Essentially accusing Lively's team of using a legal loophole, the shell company, to get information they shouldn't have. Or at least not that way.
That's a core of his sham lawsuit claim. It wasn't about a real dispute involving Vanzan. It was purely instrumental to get the subpoena.
Now, paragraph 8 adds this interesting little tidbit. Points out Friedman himself has filed plenty of Doe suits.
Okay, yeah. Suits against unnamed defendants, often used precisely to find out who they are through discovery subpoenas.
So he's criticizing a tool he uses himself, which raises the question, what makes this Doe suit a sham in his eyes, but not others?
Good point. It highlights the, let's say, tactical nature of these arguments, right? He probably believes this specific use wasn't legitimate, maybe arguing Vanzan had no real connection, no standing.
Okay, so paragraph 9, Lively's lawyers hit back, Ezra Hudson, Mike Gottlieb. They don't shy away from the Doe suit.
No, they own it. Say it was the best way to get to the heart of the online attacks on Lively after the It Ends With Us premiere.
So they're framing it not as a trick, but as a necessary investigation, a tool to find out who was behind the alleged attacks.
Exactly. Directly countering Friedman, saying this wasn't deceptive, it was essential to uncover the truth.
And paragraph 10 goes harder on that defense.
Yeah.
They say they acted on reliable information, used common tools, dozed suits, subpoenas calling them entirely lawful and appropriate.
And then comes the bombshell claim, quote, "This lawsuit unearths the Wayfarer party's documented plan, in their own words, in their own text messages, to destroy Blake Lively."
Whoa. Destroy Blake Lively, in their own words.
Yeah. A plan which they executed without transparency, disclosure, or notice, acting in a way they thought would be untraceable. That is a massive accusation.
If they have texts saying destroy Blake Lively, that's game-changing potentially.
It's the absolute core of their argument now. They're saying the Doe suit worked. It didn't just gather info. It uncovered evidence of a deliberate, malicious plan documented in the other side's own messages. The emphasis on their own words is key.
And they wrap that paragraph saying they have absolutely nothing to hide. Voluntarily disclose the subpoena, expect it to come out in discovery.
Projecting total confidence. It's a move to look transparent, reinforce their narrative that this is a careful, justified investigation that found serious wrongdoing.
Then paragraph 11 brings up that deleted Facebook post from Jennifer Abel.
Oh, yeah, I remember hearing about this, posted after Lively went public with her allegations.
Abel apparently wrote she and Nathan were prepared for it, meaning the attacks on Lively, but didn't have to implement anything because the internet was doing the work for us.
Oof. Even deleted, that sounds pretty bad. Like they anticipated or even welcomed the negative backlash.
And the article connects it to the Amber Heard situation during the Depp trial, pointing out Nathan reportedly helped Depp's side then too. That comparison, it has weight.
It really does.
Yeah.
Suggests a potential pattern or playbook, maybe. Lends credibility to the idea of a coordinated online campaign rather than just random internet noise.
Which leads to paragraph 12, the impact. They mention alleged damage to Lively's businesses, her hair care line, her liquor brand, Betty Buzz, right around the movie release.
Right, so this wasn't just abstract online drama. They're claiming real financial harm, tangible consequences for her ventures.
Makes the stakes even higher. It gives a clearer motive for why she'd pursue this so aggressively.
Definitely adds another dimension, potential economic damages.
Okay, paragraph 13. We get a trial date, March 9, 2026. So this is going to be a long haul.
Yeah, settling in for the long run.
And it mentions Lively, Reynolds, Sloan, even the New York Times are all trying to get dismissed from Baldoni's huge countersuit, that $400 million defamation claim.
Right. And the NYT published that big expose, "We Can Bury Anyone," with those Nathan Abel texts, not long after Lively filed her initial complaint.
Yeah, the timing was interesting. But the NYT getting dismissed seems likely, right? First Amendment protections for reporting on news?
You'd think so. Reporting on court filings and related matters is generally well protected. Seems like a strong argument for them.
Okay, paragraph 14 circles back to Stephanie Jones. Still unclear exactly how Lively's team first got the info from her, but suggests it happened around late August.
Yeah, the exact how is still fuzzy. The article says Jones's own declarations and testimony will likely reveal those details later in court.
So we wait for the legal filings on that one.
Oh.
But the timing is interesting. Late August. Wasn't that around when Baldoni publicly hired Melissa Nathan?
That's a point some have raised. Nathan's hiring was reported mid-August. Given her reputation, especially after the Depp case, maybe seeing her come aboard, combined with negative online chatter. Perhaps that's what triggered Lively's team to really start digging.
It's plausible, right? Even without hard proof yet, you see someone known for aggressive tactics hired just as things turn negative online. You might start asking questions. Lawyering up.
And maybe they had already lawyered up before that. There was mention somewhere of a list of demands sent earlier, including a no retaliation clause. Suggests they were already concerned before Nathan was officially on board.
Good point. So the timeline might be even more complex. Okay, paragraph 15 gives us a date for the subpoena to Jones, October 1st.
And the scoop was huge. Electronic records, data, documents, communications, going back to December 1st, 2022, relating to Lively, Reynolds, their companies.
Casting a very wide net. Looking for anything relevant over almost a year.
Seems like it. A comprehensive search.
Paragraph 16, the handover happened quickly after the subpoena. And then, crucially, the Vanzan suit was withdrawn December 19th.
The day before Lively filed her main complaint with the Civil Rights Department.
That timing feels incredibly deliberate. Get the info via Vanzan, then drop that suit and immediately file the main one, armed with the evidence.
It really looks like the Vanzan suit served its specific purpose, get the discovery, and then was immediately closed once that goal was achieved, paving the way for the public filing, like legal chess.
Exactly. Playing legal chess. Wait, paragraph 17 revisits why they wanted Jones's communications. The article suggests the messages indicated a coordinated attack on Lively to preempt any revelations about Baldoni's alleged misconduct.
So the theory is Baldoni's side knew something might come out, so they tried to discredit Lively first.
That seems to be the implication.
Hmm.
And it adds another context. Jones was reportedly losing staff and clients around when Abel started her own PR firm.
The PR firm feud angle. So professional rivalry could have been a factor in Jones maybe being willing to share information.
It's possible, right? Adds another layer of intrigue. Maybe that call between Sloan and Nathan back in August wasn't just about Lively. Maybe Sloan was warning Nathan about Jones being upset over client poaching or something. It gets complicated.
Very. And remember, paragraph 18 reminds us Judge Lyman himself cautioned the lawyers back in March about the feud between PR firms being part of this whole mess.
Right. Good reminder that it's not just the stars. It's their teams, their histories, their rivalries playing out too.
Absolutely. And finally, paragraph 19 notes, the Daily Mail was actually first to report the Vanzan suit existed.
So much for a shadow suit, staying completely in the shadows.
Yeah, these things have a way of coming out eventually, especially in high-profile situations.
Okay, so wrapping this up, it's way more tangled than just sham lawsuit versus nothing to hide.
Definitely. You've got these serious accusations of a planned smear campaign backed up, apparently, by texts obtained through this Vanzan lawsuit.
Which Baldoni's side claims was an improper use of the legal system just to get those texts.
And the timeline suggests a very careful strategic investigation by Lively's team, maybe starting earlier than we thought, possibly triggered by specific hires or online activity, and culminating in this evidence grab right before they went public.
It's a masterclass in legal maneuvering, maybe.
Precisely. We aim to unpack the details here, lay out the sequence and the arguments from the sources we have, not declare a winner.
Absolutely. But it really makes you think, doesn't it? Seeing these conflicting stories, the alleged evidence, what does it say about how these Hollywood battles are sought? Especially with the internet as this huge amplifier.
And the power of PR, the alleged smear campaigns, the untraceable plans. What are the real costs, not just legally, but reputationally, financially, for everyone caught up in this? It's a lot to consider.
Definitely something to keep watching and thinking about how narratives get shaped, both in court and online.